Hello everyone. Welcome back to our channel U.S. Immigration News. We hope you're doing great. Well, in today's video, we will be talking about October 10th as a key day for parole in place for undocumented spouses of U.S. citizens. As the October 10th deadline approaches, the Parole in Place program has become a focal point for undocumented spouses of U.S. citizens seeking a path to legal status. This initiative, designed to protect families from the devastating impacts of deportation, allows eligible individuals to remain in the country legally while their applications for permanent residency are processed. With this crucial date on the horizon, many families are anxiously navigating the complexities of the immigration system, hoping for the opportunity to secure a more stable future together. In this piece, we will explore the significance of the PIP program, its eligibility requirements, and the potential implications for families facing uncertainty. If you are interested in this, so to get all the information, pay attention and watch the video through to the end. Please hit like and subscribe, and don't forget to push the notification bell for an upcoming video. So, without any further delay, let's jump into the video. The Parole in Place allows about 550,000 undocumented spouses of U.S. citizens and undocumented stepchildren, all of whom are not legally admitted, to complete the adjustment of their immigration status and receive a green card within the United States. A panel of judges from the Fifth Circuit Court of Appeals based in New Orleans will hear oral arguments on Thursday, October 10th, on the Parole in Place, an immigration program created by the Joe Biden government that allows about 550,000 undocumented spouses and stepchildren of U.S. citizens to adjust their residence, but which was stopped by a federal court in Texas. The hearing will take place on the same day and before the same panel that will hear arguments on the 2012 Deferred Action for Childhood Arrivals program, which was declared illegal in September 2023 by Judge Andrew S. Hanen of the 9th District Court of the Southern District of Texas, but which allowed some 560,000 Dreamers to remain protected from deportation for 2 years, until September 2025. These are two fundamental lawsuits directed against DACA and the Biden-Harris administration's new process for keeping families together. Parole in Place, said FWD.US, a lobbying group made up of leaders in the technology community, including Facebook, LinkedIn, Google, and Dropbox. In their attempt to dismantle the two most significant immigration relief measures of the past generation, both lawsuits represent an unprecedented attack that directly affects millions of people, it added. Another coincidence is that both lawsuits were filed by coalitions of Republican-governed states led by Texas. They are part of a coordinated effort by anti-immigrant groups and former President Donald Trump's closest advisors who are trying to lay the groundwork for a massive family separation agenda, the organization said. The appeals court overturned a lower court's decision. On September 13th, a panel of judges from the Fifth Circuit Court of Appeals ordered a Texas federal court to administratively suspend all proceedings related to the in-place parole program, which was temporarily suspended in August by order of federal Judge J. Campbell Barker. Co. In late August, Barker temporarily ended the program in response to a lawsuit filed by a coalition of Republican-governed states led by Texas, who alleged that in-place parole is illegal because it grants immigration benefits without congressional authorization to foreigners who do not have legal admission to the country. While the ruling allows the Bureau of Citizenship and Immigration Services to continue accepting I-131F forms for enrollment in the program, the ruling prohibits the federal agency from processing and adjudicating parole applications and obtaining the benefit offered by President Biden. The parole, in effect, allows about 550,000 undocumented spouses of citizens and stepchildren, all of whom are not legally admitted, to complete the adjustment of their immigration status and receive a green card within the United States. The program allows people to skip the consular process and avoid putting their return to the United States at risk because undocumented immigrants, once they set foot outside the country, are automatically subject to the punishment law, which punishes them for 3 years if they remain undocumented for more than 180 days and increases to 10 years if they remain more than 365 days. Key day for the immigrant community. For FWD.US, both the hearing on parole and the hearing on DACA, simply put, there will not be a clearer demonstration of what is at stake for the future of immigrants and mixed-status families in our country before Election Day next Tuesday, November 5th. This day of hearings, October 10th, will be about a coordinated effort to strip or deny protections to more than 1 million people who have lived, worked, and contributed to every community in our country for decades so that they can be abruptly deported in 2025, the organization said. The Fifth Circuit panel of judges hearing the appeal ordered a hearing, and in the order issued Wednesday explained that it has set a schedule for the presentation of arguments. It added that this merits panel has set the oral hearing for October 10, 2024. The September order from the Fifth Circuit Court of Appeals panel said that in light of criticism of the district court's recognition of the need for expedited resolution, this panel has the opportunity to consider arguments on the merits, scheduled to be received by September 16th, and to hear arguments on the appeal of the denial of intervention. Accordingly, it rules that we are administratively staying proceedings in the district court pending a decision on the merits or other order from this court. The stay issued by the district court will remain in effect pending further order from this court. The order concludes by saying that nothing herein should be construed as commenting on the merits of the appeal at issue, on the intervention, or the underlying substance of the litigation. They can protect American values by rejecting these attacks on programs and repudiating those who cynically play politics in the courts, or they can choose to stand by and watch the growing existential threat facing millions of American households who count on them to do the right thing. As the October 10th deadline for the Parole in Place program draws near, the stakes are high for undocumented spouses of U.S. citizens. This initiative offers a glimmer of hope for families striving to stay together and build a future in the United States. Understanding the eligibility criteria and application process is crucial for those who wish to take advantage of this opportunity. While the road ahead may be fraught with challenges, the potential for legal protection and family unity underscores the importance of advocating for equitable immigration policies. With support and perseverance, families can navigate this pivotal moment, ensuring their voices are heard and their rights are upheld. That is all for today in this video. What are your thoughts on this? Please let us know in the comments section below. Thanks for watching the entire video. Hopefully the information is useful to you. See you later in the next video. Till then, take care.
Hello everyone, welcome back to our channel US Immigration News. We hope you are doing great. Well, in today's video, we will be talking about October 10 as a key day for a parole in a place for undocumented spouses of US citizens. The Parole in a Place program introduced by the Biden administration holds a significant promise for approximately 550,000 undocumented spouses and stepchildren of US citizens who are not legally admitted to the country. This program allows them to adjust their immigration status and obtain a green card without having to leave the United States. As we approach a pivotal moment in this initiative, the Fifth Circuit Court of Appeals is set to hear oral arguments regarding the future of PIP on October 10, 2024. This date not only marks a critical juncture for PIP but also coincides with a separate hearing on the Deferred Action for Childhood Arrivals program, which has been a vital protection for many undocumented individuals since its inception in 2012. In recent months, the PIP program has faced significant legal challenges. A federal court in Texas halted the initiative, arguing that it unlawfully grants immigration benefits without congressional approval. This ruling came after a lawsuit filed by a coalition of Republican-led states claiming that the program's implementation violates exciting immigration laws. The Fifth Circuit Court has since ordered a temporary suspension of the lower court's decision, allowing the Bureau of Citizenship and Immigration Services to continue accepting applications but prohibiting the processing of these applications. The implications of the October 10 hearing are profound. FWD US, a lobbying group composed of tech industry leaders, emphasizes that these two cases represent concerted effort to dismantle crucial immigration relief measures. Both PIP and DACA are under threat from the aggressive legal campaign led by anti-immigrant groups and former President Donald Trump advisor, and aid separating of families and imposing stricter immigration controls. FWD US argues that these legal battles not only jeopardize the futures of countless families but also reflect a broader political agenda that disregards the contribution of undocumented individuals to American society. The stakes could not be higher for undocumented spouses and stepchildren who stand to benefit from the PIP program by allowing individuals to avoid the consular process. The program helps prevent a risk associated with the punishment law, which imposes penalties on undocumented immigrants who leave the US after residing here unlawfully. This video offers a vital avenue for families to remain together and avoid the trauma of separation. As we approach the October 10 hearing, the immigrant community FWD US highlights that this day will serve as a crucial moment to demonstrate the significant stakes involved for millions of mixed status families. With the impending elections, the outcomes of these hearings could have lasting ramifications of immigration policy and the lives of those who have lived, worked, and contributed to their communities for years. The decision in a court will not only shape the future of the PIP program but will also serve as a litmus test for the Biden administration commitment to protecting immigrant rights. As the families navigate this critical juncture, understanding the eligibility criteria and application process remains essential for those hoping to take advantage of this program. With unwavering support and advocacy, families can work toward securing their rights and ensuring that their voices are heard in this important conversation about immigration policy in the United States.